Welcome everybody to Avoiding Employment-Related Legal Challenges. I am Dave Lowe. I'm the CEO of ISI Federal. I'm also the GovBrief host today. And with us, we have Mr. Mike Mariachi from Mariachi Management Group. Welcome aboard, Mr. Mike.
Glad to be here.
Yeah, awesome. Well, it's great that you're here. And just so everybody knows, there's some briefing controls. You can make some things magic on your screen if you like to. Just go up to the view options and check whatever you like. You can also make Mike bigger or smaller. If you don't like the way he looks today, you can probably even make him disappear altogether if you want death by PowerPoint. But none of us want any of that, I don't think. So participation is easy. You can chat. You can raise your hand. You can even enter Q&A. We'll try to keep up with that with everybody. We'll be answering questions more towards the end of this process and into this program, but we'll make sure that we get to you. And if not, you can always reach out to Mike at mike@resettheclock.com. That is right down the bottom. It'll be there the whole time if you want to, since this has some legal things. And I do believe you're a lawyer, or do you play one on TV, Mr. Mike?
Well, you can think of me as a recovering lawyer. My job is to make sure the participants don't get to meet any lawyers, and I don't have any hourly rates. Okay, period.
Yeah, right. There you go.
My job is to make them all self-sufficient. If that's if there's a problem, I'll take care of it. They get help. They don't get bills.
That's right. Very, very good. Love it. So we're going to be flipping some polls around and make sure we get some feedback from you so that we can get your information and get you what you need. Why are you here today? Do you have an employee-related lawsuit happening right now? Some people do. I think so. I had an employee-related lawsuit, and I don't want another one. Got to love that. And then I want to know how to avoid litigation. Everybody should be picking that one, as a matter of fact. But there you go. So we'll leave that open for just a minute. Mr. Mariachi, we're going to be talking about your group. Tell me about you and how you got started in this world while these people are answering this poll.
Well, I led a legal team at Frito-Lay, and we were responsible for all employment-related litigation nationwide. And my team managed to win every single lawsuit filed against the company in state and federal court for 5 years. Made the front page of the Dallas Morning News on a Sunday in the business sector for doing that. And I know why we won them. We had a thoroughly effective compliance-based training program. I know, it was mine, but I also realized it had a weakness. Yeah, it set us up to win lawsuits, but it wasn't going to stop us from having them. So I created a program that's practical employee relations, shows leaders what to do instead of what not to do. And I'll give you some more details on that later, but call it Reset the Clock. I'll explain that. Is that what you're looking for, Dave?
I am. I'm going to end this poll in 3, 2. We have almost everybody participating except for some people who are not paying attention. So we're gonna make them pay attention. That's what we're gonna do, Mike.
Okay.
So there you go. Here's the results. I do believe that we got the right folks here, and we do appreciate you guys joining us.
Good.
So so you were mentioning Reset the Clock. I love the stories. I'm hoping you get to tell some stories here today because Mike's stories are crazy stories.
Well, Dave, thank you for introducing me and to our attendees. I intend to make your participation worthwhile from your perspective. Today's webinar is focused on avoiding employment-related lawsuits because most employee relations issues, causes more litigation than any other type of issue facing employers today. Now, regardless of the outcome, next slide.
Okay.
Put the wheel up if you can find it.
Oh, that's right. We need a disclaimer, first of all.
Oh, yeah. Okay.
We are going to be talking about legal stuff. So read this disclaimer. So this is educational purposes only. So not legal opinions and not legal advice, right, Mike?
There you go.
There you go. There we got it. So you see, everybody knows.
All right. Now, about this legal wheel of misfortune. Regardless of whether you win, lose, or settle, the legal fees and court costs in one case before a jury can cost you $200,000 or more. It used to be if a lawsuit was lost, the employer wrote a check to the employee, but now personal liability is a real possibility due to new laws and as a result of employers claiming that a leader is solely responsible to the employee because the leader violated their policies. Big ouch. Okay. About this reset the clock I mentioned, it's a process built throughout the program that when it's delivered on site, it prevents an attorney from taking something leaders did wrong or didn't do in the past and using it to attack them in future legal challenges. When delivered on site, both employer and personal liability clocks are reset to zero. The editor for the Dallas Morning News told me something and wanted my opinion about it. Mike, I've been asking the top leaders of the big employers in the Dallas-Fort Worth Metroplex the same question. Why do we keep having so many lawsuits when the employment laws have been around for so long? I keep getting the same answer. We have the best of intentions to comply with the law. I responded, that's what they're telling you, that they have the best of intentions? We may judge ourselves by our intentions. Everybody else judges us by our actions.
That's right.
Good intentions won't keep any employer out of court. Fortunately, a good faith effort will. Let's take a look at that. Next slide, Dave.
Yep. This next one? Okay.
Keep going. Oh, well, we already covered that. Keep going.
All right.
Good faith effort. What does that involve? If you have excellent written policies, training on the policies of your leaders and your employees, then active enforcement of the policies by your leaders, that's a good faith effort. If there's a deficiency in any one of those areas, employers have liability exposure. Establishing a good faith effort inside an employer is the focus of what I do, in addition to helping them maintain it. So we go through the various scenarios we've selected for this webinar. I want you to know the beliefs behind it all. I think most leaders want to exercise their leadership abilities with professionalism, integrity, and fairness. I believe the vast majority of your employees want to do their jobs like they're supposed to. But if you lead people long enough, there are plenty of chances to run into potential liability situations. In these situations, leaders who know what to do and how to do it have a significant advantage over those who don't in avoiding lawsuits. Okay, objectives. You're going to get some specific practical advice today on how to keep you and your employer out of court. Second, how to keep your employees feeling good about you. You see, employees don't actually quit their employer. They quit their leader. And the last thing on the slide, I want to make sure you know how to keep others from getting access to your bank accounts. Well, that is the plan. Now, the strategies on this next slide, your employer can make this plan work through a leadership team that's skilled in preventing legal problems rather than having to resolve them, leading people in such a way that they are doing it right, and it looks like they're doing it right. And the last thing, how to balance employer rights and employee rights. Neither of these sets of rights is absolute. Most folks are surprised to learn that the courts are equally protective of the rights of employees and employers. It's regrettable that employees learn about this dual protection in court rather than on the job from their employers. There's another fact that if employers shared it with their employees, could go a long way to keeping employees and leaders out of court.
So can you give us an example of that, Mike, where the courts look at employees and employers and how they view it?
Yeah, I can. An organization decides it wants to present a more professional image. At their expense, they buy logo shirts, give the employees free shirts, and tell them, so we look nice in front of our clients, we're all going to tuck our shirts in. Employee says, thanks for the free shirt, but I'm not tucking it in. As a condition of your continued employment, you'll tuck the shirt in. He refuses, gets fired, goes to an attorney. Free speech applies in this country, doesn't it? It sure does. Let's file a lawsuit. What did the judge say? There's no constitutional right not to tuck your shirt in. If employers want to establish a rule, you got to follow it. Did the attorney lie to the employee? No, he just didn't tell him that the question and the answer were irrelevant. Leaders play a primary role in protecting themselves and protecting their employees from lawyers that take advantage of employees not knowing the law.
And you see that all the time.
All the time. Okay. Okay, about this next slide, about this other fact. All legal challenges to decisions leaders make exclusively on the basis of attendance, performance, and conduct are invalid. Getting leaders to understand and apply this concept can be effectively accomplished through training. Dave, let's take a quick poll of our participants to get their answer to this question.
Right.
Do it right and be perceived as right. In terms of avoiding lawsuits, is one of them more important than the other? And if you think so, which one? Now the slide gives you 3 choices. Post your answers as quickly as you can.
Hang on a sec.
And then we'll see where we go.
There we go. There it is. So in terms of avoiding lawsuits, is one more important than the other? And which one do you think is more important? Doing it right, perceived as right, or equally important? Give us some examples while we're doing this. Give us a story from your days of some of the times where you're at Frito-Lay, because that's a nice organization. Give us some good examples when something happened.
Well, I realized that the reason we were winning all these lawsuits, it wasn't brilliant lawyering. We just had the facts on our side. We could prove we did it right in court because we had the evidence, documents, and testimony. What I also figured out is we were doing a lousy job of managing perceptions. Okay.
We can't think of anybody else that has a problem with perceptions in the media. Not one.
So I had a lot of stuff to fix. Okay, are the answers coming in?
Yep, they're right. We're going to give them another 10 seconds. So give us the rest of the story.
Okay. Well, I set about figuring out how am I going to deliver this to an organization of 20,000 employees, with sales units, over the road units, unionized, ununionized, but I did figure it out. Okay. What I didn't realize is that as top HR people left Frito-Lay, they reached back for me. You got to do it at Sara Lee. You got to do it at Texas Instruments. You got to do it all these defense contractors. Now, a lot of the tactics I'll be sharing with folks today, I've actually used when I was CEO of General Technical Services for 5 years. We had one client, the military. Most of our scientists and engineers were in
real
Maryland.
Quick, Mike. Real quick.
What do we got?
Look at this. Who's right in this? Doing it right, perceived as right, or equally important?
Well, one thing is clear from looking at this feedback. It's clear our participants are not all on the same script, and all leaders at an employer should be on the same script, and it better be the right script. If you do it right, you get to win lawsuits. If you're perceived as right, the lawsuits don't get filed. But there's a problem with being perceived. What if it is smoke and mirrors, form without true substance? You can get away with that for a while. Eventually, somebody figures it out, shares it with others, then you get to lose lots of lawsuits. Doing it right and being perceived as right are equally important. So there was no need to go to the second half of the question. Okay, I admit it. It was a trick question. When an attorney asks you a trick question in court, it's designed to make you look bad. When I ask a trick question, either during webinar or when I'm doing this program on site, is designed to make you look good on the job.
There you go.
Okay.
So tell us about difficult situations. What do you mean by being fair?
All right. Well,
being consistent.
There's a big advantage to making mistakes in training. You don't make them on the job. We have to have the same definition of right. Obviously includes following the law, but that's not enough. How does everyone be treated on the job where you work? It's fair. Why is that important? Race, age, and sex discrimination, it's all illegal now. Wasn't always. Became illegal in the mid-'60s. Prior to that, it was legal, but it was unfair and stupid. Now, thanks to these statutes, it's illegal, unfair, and stupid. There's some things today that are unfair. They're just not illegal yet. So it's an opportunity for you and your leaders for your leaders to get your employer's name in the law books. To prevent that from happening, everything leaders do must be.
So when you
legal
say
but
get
fair.
their employer's name in the law books, you're talking about somebody hitting the Supreme Court
Yeah,
somewhere along the line?
yeah. Well, it's not just Supreme Court cases; it's the district court cases, the
That's
circuit
right.
court cases. You know, you can get looked up.
And that's
It-
one thing that is really important, is that your approach is not to go into court and win. It's to stay out of court and never have to be there.
That's right.
That's
okay.
it.
Okay.
And we're going to pick. So we
Now,
think
about this
consistent and
slide, the
fair.
difficult situation. Let me tell you about that. Obviously, when you terminate someone, I know that you all want to be fair and you want to be consistent. You want to be both. But when you're forced to choose between being fair and consistent, pick fair. An example, 2 employees on the same day committed the same infraction. The handbook stated this called for corrective action and or termination. One employee got discharged. The other received corrective action. What was the distinction? The discharged employee had 2 years of service, performance problems, and other write-ups for misconduct. The other employee had 12 years of service, good performance appraisals, no prior write-ups. But there's a way to think about the relationship between being consistent and being fair. Being consistent just requires memory. Being fair requires thought, and that's what we're supposed to be, thoughtful leaders. My goal is to provide leaders with practical knowledge and competence in handling issues so that they all stay out of court. Practical knowledge. That's 2 words. Can I take it down to 1?
Mhm.
Wisdom. There's a
Nice
big
word.
difference between knowledge and wisdom. Knowledge is knowing a tomato is a fruit. Wisdom is not putting it in a fruit salad. All
There
right.
you go. So let's talk about
Okay.
attendance, performance, and conduct, because this is what everybody should be pointing to, as opposed to anything else to take you off track. So explain how this works.
I will tell you, I have fired lots of leaders. I grew up with scientists and engineers, and that's how my mindset was formed, and going to law school didn't change it. But I had to fire leaders for failing to meet my standards, failing to discriminate. I did, because there's illegal discrimination, and then there's required discrimination. If I have leaders that can't make decisions on attendance, performance, and conduct, I'm going to replace them. Get leaders that will. Okay. Now, when you have to make changes to these 3 things, attendance, performance, and conduct, your decisions don't have to be popular. You don't have to be popular to be respected. Changes may not even be popular with some first-level leaders, but they get it. Same with most employees. Unfortunately, over time, you may have 1 or 2 that don't get it. Some of them don't seem to get anything, so that you don't have to worry about that. And to protect your employer, there's a rule. When changes occur, employees must accept them or quit. If an employee continues to work after you've put a change in play, the employee is deemed to have accepted the change for all legal purposes.
Hey, Mike,
Yeah.
real quick.
Mhm.
In answer to that, I got a question from somebody, from Daniel. He says, so was it fair to terminate one and not the other?
It was fair. What drove the difference is different levels of service,
Mhm.
different history of progressive discipline, and different levels of performance. All that factored in. That's what, taking those things into consideration, is called being fair. Okay.
Yeah.
All right.
Thanks, Daniel.
Now, okay. To protect employees, there's also a rule, and that's reflected by this screen. You have to provide adequate notice. Changes are only enforceable if you have adequate notice. What's that mean? You could announce this change in performance or attendance goes into effect next month, next week, tomorrow. All these notices are okay, but they all state the change will apply starting at a fixed future date. Okay, the next thing on this slide, reasonable. Employees are protected from intolerable working conditions. Hey, new receptionist was told that we've got a lot of open positions. People are coming in to apply for them. I don't want to have to deal with any minorities. Your job's to get rid of them. I don't care how you do it. You want to lie to them and tell them job's filled when it's not. It won't bother me. It would bother me if you didn't do your job. She quit rather than do that, filed a lawsuit, and won heavy damages for her being discharged. How did that happen? When a leader makes an employee's working conditions so difficult or so unpleasant that a reasonable person feels compelled to resign, that resignation is treated as a discharge. Asking an employee to participate in an act of discrimination is on the list of intolerable working conditions. Having too much work to do with unrealistically tight timeframes didn't make the list. Too bad, huh? But a lot of our listeners would have had a valid complaint. The changes have to be conspicuously presented. What's that mean? You have a meeting. If you meet these standards, any employee doesn't quit, is bound by the change. One employee's unsuccessful argument was, not quitting shouldn't be held against her because she was poor, needed her job. Well, here's again, employers' rights took precedent, and that was the end of that case. Now, what did not knowing that lesson cost her? At least $10,000 in legal fees is what an employee will have spent. Okay, if you explain things to employees, not only do they not pay $10,000 in legal fees, you don't spend $200,000 in winning the case.
Yeah.
All right. Now, let's talk about how you make changes to attendance, performance, and conduct. Employee resistance to change is minimized when they understand it due to adequate communication. So I'm giving you a procedure to use when you're making changes to those types of standards. First thing I want you to do, tie in with HR. Then you conduct a meeting. If some of your employees happen to be represented by a union, the union is entitled to notification, not negotiation. Okay.
That's a big deal.
Well, it certainly is, because I had another job at Frito-Lay. I was chief spokesman on behalf of Frito-Lay and union contracts all over the United States. Now, back to the meeting. Explain to your employees what the change is, why their commitment to it is important, and the future date's going to go into effect. Ask for and answer their questions to confirm they know what they've got to do to comply with the new standard. So what's the question you want to ask? Can I have your commitment to the new standard? Because asking that question is such a simple thing to do and is totally within your control. If you don't ask that question, nothing happened that day for legal protection purposes. You have to ask to get. Now, that is a question. Here's what won't work. You announce something. I'm holding you accountable to meet the new standard. That's a statement. That accomplishes nothing. You got to ask the question. All right. What about someone voices an objection when you ask for the when you ask the question? Just tell the whole group, I'm available to discuss in private any personal concerns about the new standard. You're a little ahead of me on the slides, Dave. Okay. So if you are approached in private, explore assistance in the employee meeting the standard. A big problem often occurs when untrained leaders adjust group standards based on an employee's personal circumstance. You don't want to do that. What you want your leaders to say, here's what can be done to help you meet the standard, but it's got to be met by everyone. Now back to the group meeting. Tell the group that failure to comply will result in an appropriate response. And now the meeting is over. Let HR know you held this meeting. By the way, HR should not attend this meeting. If employees see HR there, they will think you've got HR in your pocket. They'll go to an attorney rather than go to HR.
That's good advice. So when you have these procedures, you leave HR out?
Well, in this meeting, HR should attend a lot of meetings, but the one meeting HR does not want to be present is when a leader is making changes to attendance, performance, and conduct standards. By the way, the HR Pro version of this course is also a 2-day program, but I don't get to cover the leadership version, and I'll talk about that later. All right. So what do you want whoever's running the meeting to do? Document the date and content of the meeting. And rather than asking employees to sign an attendance sheet, have a list of names to call out and mark up that they're there. You see, it's continued employment, not signatures, that binds employees to the standards. What about email? It doesn't take the place of a group meeting where having a meeting is practical. What you should use email for is after the meeting to reinforce what was discussed in the meeting. And options for those who missed the group meeting, make-up meeting, or for those that aren't there, an email. If they're working remotely, then you have no choice but to send them an email. Okay. Okay, now we're going to go to responding to employee complaints. Responding to employee complaints properly can resolve issues internally and eliminate the perceived need for outside intervention of any type. So if an employee comes to you with a complaint of unfair treatment, look directly at the employee. Avoid showing interest in anything other than that conversation. You're going to be taking notes, which you'd read back to the employee and ask this question: did I get everything you said down right? When you get a yes, that confirms that your notes are correct, that they're complete. By documenting this question and answer, you've locked the employee into their version of the facts, so attorneys can't rewrite history later.
Yep. And let me real quick, Mike, it's so important to be present when you're having those communications, and that gives you the ability to listen carefully. I had the opportunity of meeting Mr. McDonald. He was the head of the VA for a while, but he ran Procter & Gamble for many years as CEO.
Mhm.
And I can tell you, he was one of the most present people. When I was talking, I had about 5-minute conversation with him. But the ability for people to if you say, hey, connection with the eyes, I think that's great advice. And then making the notes and then feeding it back to them and say, did I get it right? Really, really good advice. Really good advice. That's great for every leader.
Okay. What else there's certain things we want leaders not to do in this meeting.
All
Don't
right.
make any comments about the merits of the complaint. Any impulsive remark, legal trouble. No leader to say, okay, we got it. We'll go to HR, but you got no case. Making a spot judgment that an accusation couldn't be true is an invitation to a lawsuit. No leaders to say, you got a good case. Accepting a complaint at face value is equally hazardous. Let HR run the investigation. Every complaint is unique, has to be judged on its merits after a complete investigation. Okay, what do you want to do? You've got the complaint. Prompts look into the matter, and with the employee watching, you do it. You try to get HR on the phone. Okay, if you don't get them, say, I'll get to HR, I'll be back in touch. Whatever you do, don't tell an employee, you should take this up with HR. Why? The employee came to see you. If your policies are worded correctly, they tell people to go where they're most comfortable. The employee's most comfortable coming to you. Talking about unfair treatment is an emotional experience. Now, having told you about it, the employee's emotionally spent. Saying take this up with HR can result in the employee walking out, not going to HR, contacting an attorney. Many policies that I review in preparation for on-site program name things like go to HR, go here, go there. Well, here's the problem. According to the law, notice to any leader is treated as notice to the employer. When judges have to choose between enforcing law and enforcing policy, guess which one they're going to pick? All right. Now, not every complaint of unfair treatment has to get turned over to HR. If the complaint is against you and you have a simple fact that's likely to result in a quick resolution, share it with the employee. An example, employee asked the leader, why did you sign me to work this Saturday rather than anyone else? How's that fair? The leader responded, you're out on paid time off 2 days this week. Everybody else has their 40 hours in. If you work in straight time, finish up by asking the employee, now that you know that, do you still feel the same way? No, I didn't know that. No problem. Thanks for letting me clear this up. These are simple scripted things that keep leaders and employees with a good relationship staying out of court. All right. Okay. Now, the next slide. If you are ever asked not to report a potential policy violation, I'm required to report all potential violations of our policy. This matter will be kept as confidential as possible. What employers should have a record is that all their leaders were told what you'll see on the next slide. Not reporting a potential policy violation is an actual policy violation by the leader. Okay. There are employees that will ask you to keep something off the record. Well, Next slide, please. There's no such thing as off the record.
That's right.
Okay, you can't get it off the record. All right. Next issue I want to talk to you about involves charges of discrimination. When I got to Frito-Lay, there was well over 100 charges of discrimination in the monthly float. It took
100 charges a monthly float?
The monthly float, in and out, the monthly float, they're stuck around 100. It took me 9 months till I got the monthly float to below 30. Okay. My goal was to eliminate my job. Well, they found other things for me to do. All right. Here's what I want you to understand. Don't engage in an informal discussion about the charge or the charge's validity. One slip and you could be charged with retaliation. So if an employee brings it up, I'm going to give you something clearly neutral to say. That's interesting. I don't know how it's going to turn out, but I'm not comfortable talking about outside the investigation HR is conducting. And then I want you to document the incident and the exact wording of your response, then notify HR.
Yep.
Why did I say exact wording? If what you said is what you see on this slide, no liability for retaliation or anything else. But if you said, that's interesting, you'll see, I don't know it's going to turn out, finished it out, you're going to get hit with a charge of retaliation. Spoken words, when written down, tone and inflection of voice is lost. If you said, you'll see, a plaintiff attorney could put an employee on the stand to say, I was threatened. It sounded like, you'll see. Okay, well, just great. It's these little simple things that if leaders understand them and put them into practice, they're in good shape. Now, some employees have a misperception. Now that I filed a discrimination complaint, I'm going to get treated differently around here. There are leaders that have a similar misperception. Now that this employee has filed a complaint, I have to treat them differently around here. Treating an employee worse or better after the filing of a complaint will both be treated as an indication of discrimination. There is a safe course of action. Continue to make decisions on attendance, performance, and conduct, just like you did before you knew about the complaint. The big yawn at the EEOC is an employee thinks they're going to get discharged, files a complaint of discrimination, gets discharged, and then files a claim of retaliation. It's a big yawn. They know that what's going on. Okay, so the safe course of action, what we did before, we did after. Okay, next thing, non-specific complaints. You've been counseling an employee about a performance or a conduct issue, and then you had to do it again, and then again and again. At some point, the employee complains, when are you going to stop harassing me about this? Now, the employee has not identified any specific protected status. Don't you do that either. If you get defensive, you may end up needing a defense. So don't say, this has nothing to do with your race, sex, age, whatever. Saying that would put it in the employee's mind that a protected status is in your mind. Denials lead to disaster. So instead, say this. You have to meet the standards that I've made clear to you. When I see a problem, I'm going to tell you about it. This provides you with an opportunity to correct it. This process will continue till the problem is resolved. Document the incident, including your response, and notify HR. Can't tell you how many times this has kept employers out of court when leaders knew that.
That's fantastic. I love that advice. It's great advice.
Okay.
So what is a performance problem?
Well, before we get into that, sometimes the bigger issue is how a leader responds to a problem. How a leader feels is not always the best judge for what that leader should do. What you should do is understand each situation, be clear about what's required of you, and then to respond fairly and professionally. A good first step is to figure this out. Are you dealing with a problem employee or an employee with a problem?
Oh,
okay. And that's a very good first step.
that's nice.
Now, about this definition that you see, be sure the issue actually involves quality and quantity of work. There's a different set of tools for addressing policy violations and misconduct. The failure to point out this distinction has often resulted in leaders with the best of intentions picking up the wrong toolbox. Handling misconduct and policy violations might be a good topic for another webinar, but we'll have to let it go for this one. Dealing with performance issues as early as possible prevents them from becoming more serious and more distasteful for you and the employee. With that in mind, alert an employee immediately when you observe poor performance. Give the employee an opportunity to correct it. Here's what happens if you're displeased with an aspect of an employee's work and don't tell them right away. The employee approaches you at work and asks you a question, and you answer it. But your tone of voice and choice of words has the employee thinking you're upset with him. He doesn't know why. He starts guessing. There are lots of wrong guesses tied to protected status the employee could make. 4 weeks go by, and now you bring the issue up. I noticed you messed this up on this date, and as this document here shows, I saw you do it on 4 other dates as well. You know what the employee's thinking? Why didn't you tell me about this the first time you saw me mess it up? I would have fixed it then. You've just lost the trust of the employee. Because you built this list, the employee now believes you're more interested in building a case to get rid of him than to work with him to resolve problems. Trust is always a two-way street. While it existed, if your employee saw you unknowingly mess something up, he'd tell you right away before your boss noticed it. Now the employee will stop bringing to your attention your mistakes. He'll just wait and let your boss tell you about them. If you start the conversation by saying, you've got yourself a problem, you've now put the employee in a defensive mindset. That's what they'll assume, a defensive mindset. Instead, lead the employee into an assistive mindset. Just make a simple request. Hey, Mike, I'd like your help with something. Well, what is it, boss? Well, I saw a gap between what you did and what I expected, and you give them the details. What can you tell me about it? That is an open-minded and actually a diagnostic question. If you have a performance problem, it's either due to a deficiency in ability or deficiency in motivation. If the problem is due to deficiency in ability, is this an employee who we hired, claimed he had the ability, and now we're finding out we didn't get truthful information? If it's a long-term employee, we have to figure out, is this something we're supposed to train people to do periodically or refresh their training? And that may solve it. Now, it's a deficiency in motivation. Nice thing to do is explore why and see what you can do. But at the end of these 2 explorations, you've got to remember in either case to ask, can I have your commitment to correct it?
Love it. Hey, Mike, we do have some questions that we want to get to, and we have another poll here, which is, how much do you spend on litigation in the past 3 years? This is the past 3 years question. How much have you spent on employee-related legal claims in the last 3 years? We didn't have any. Less than 50, 50 to 100, 100 to 250, 250 to 500, 500 to 1 million, and over 1 million. This is over the past 3 years, ladies and gentlemen, not just one time.
Okay, let me tell you about a Boston headquartered organization with sites across the United States. They brought me into headquarters and Mike, we want you to train our people because we got too much going in the way of litigation. I said, well, what do you got? What'd you spend last year just on legal fees? And they said $1.6 million. $1.6 million, and you've got 5,000 employees. I went nuts when I hit $100,000 and I had 20,000 employees. Okay. Well, yeah, it is 100,000. It was 900,000 actually. 900. Okay, I went to all their sites, and next year, instead of legal bills of $1.6 million, it was below 250,000. That was the first year. Okay, lower after that. Okay,
because let's talk about why that happens, right? So because there are people, the legal world, right, is built around what? What is their job?
Well, if you want to know why cases go so long, I'll tell you. I never brought into this brotherhood at the bar. You got your client, I got mine. Let's keep these hourly rates going. First of all, I'm on salary. My job was to get Frito-Lay out of trouble. Okay, so how I did it when I had to respond to requests from attorneys for documents, I gave them what they asked for, and I gave them some other stuff too. And I told them why I gave them this additional stuff.
Mhm.
This proves we're positioned to win this case. You have a choice to make. Drop the case right now, because if you don't, and this is why we win the lawsuit, this letter to you goes to the judge to support my motion that you and your client be held financially responsible for our costs of defense. And the courts gave you liquidated damages ×2. So I turned the law department into a profit center. Okay, so, does that answer your question, Dave?
That does answer the question. I love it. And we got other questions too. And then we got to come to a place to wrap it up. So,
Okay.
so I'm going to end the polling in a couple of seconds, but here we go. So a lot of folks didn't have any employee related claims over the past 3 years. That's fantastic. Now, the cost of when they do happen, because they will happen if the training's not right. I think that's the most important piece that everybody needs to take, is that the information that you're giving out is really cool because it doesn't deal directly with a fist fight between two lawyers that their job is to continue fist fighting.
Yeah.
We've all seen it. There's anybody on here that has not experienced this.
There's a way to win the legal wheel of misfortune game. It's called you don't play it. Okay.
That's right.
All right. One other bit of data, and has to do with keeping records of all the spot counseling problems. When employees are terminated for poor performance without documentation of previous counseling, they go to attorneys. A performance appraisal has to be an annual recap. So kind of talk to your leaders and show them the value of talking about performance on an ongoing basis. So if you can get to the slide about performance management on an ongoing basis.
Hang on a second. We gotta wrap it up, Mike. We're at a place where we gotta wrap it up. So there's plenty of things that you guys can reach out to. I want to make sure we include some questions here because we're actually over time as it is right now. You got so much great information. I want to get to people's questions, and you guys can make sure that that we get some of those pieces together. So I'm opening it up. You can raise your hand. You can chat things. I have a bunch of questions that were formulated beforehand. So let me pause the screen.
Well, can you put up the slide on good judgment?
All right.
It's near the end of the deck.
There you go.
There you go. Okay. The reason that's up there is effective employee relations doesn't mean you just comply with the law or you follow your policy. Policies provide more fairness than is legally required, but you can't write policy to participate all conceivable situations. But if you have leaders that demonstrate good judgment, what are they doing? They're giving their employees a square deal. What are the corners? Be reasonable, be consistent, use common sense, common decency. In preparation for on-site programs, I have to review employers' policy, build them into the presentation. Many times I find that the employee relations policies were written to legal standards. Sounds right, but it can lead to liability. When policies reflect legal standards, every policy is a violation of the law. I recommend specific changes to them that reflect good judgment. So what are questions we got?
All right, we got where are the 2021 laws and how do you find them? That's from Cherry.
Okay. Well, I mean, if you go on the internet, you can Google state laws and get them that way. I mean, they're always changed. But here's the focus. If your leaders are demonstrating good judgment, they're never in violation. They're never out of compliance with their policies. They're never in violation of the law. So they really don't need to know the law. They need to know how to handle every specific situation. And there's a solutions finders in the participant manual at one page so they can get to these quickly. And I'm about to turn it into a phone app as well. So they've got something going. Go ahead.
Is there a place for those where you find those laws or?
Yeah, if you just go put the state in and put employment laws, you're going to come up with it. But the main focus is the federal law, and that's Title VII of the Civil Rights Act, which you can look up, is the Age Discrimination Employment Act. Those are the two big ones. And
here's one. Do I need to have a meeting regarding changes in policy if we put it in the employee handbook? Great question, Caesar.
Okay, in order to maximize the effectiveness of your employment-related policies, there's a procedure. Your employees need to hear it, read it, see it. That means you talk about it, they have it in the employee handbook, and then the leaders live it. The employees see the policies are actually being followed.
Yep.
Now, depending upon the industry, they may need specialized versions of this course. What we're discussing today here is the general version for leaders, but there's a special version due to the large number of healthcare organizations that wanted it. So for hospitals, they have theirs. There's actually one that keeps me quite busy in police departments for law enforcement. Then there's the HR professional version for bigger organizations that like DFW Airport, where I do the HR department there every couple of years, but big defense contractors also bring it in.
So we're a staffing company, and often our customers, is from Daniel, set and change our employees' schedules and performance standards. Are we, as the employer, vulnerable to lawsuits due to our customers' changes in schedules or performance standards? What can I do to minimize potential claims? So they're a staffing company, so they're supplying talent, right?
Mm-hmm.
How does that work?
Well, the obligations on employees are to meet your requirements on attendance, performance, and conduct, and also meet the expectations of the client's attendance, performance, and conduct standards too. So that's dual things. Okay. So balancing out those two things, hopefully they're not too much out of alignment, but I would tell an employee, look, what this client has asked of you is something you've got to do. Mm-hmm. If you aren't capable or willing to do it, then I can't put you at that client. Mm-hmm. Hopefully that's what they wanted, the way of an answer.
And so Monica is asking a question. Are there any future courses or materials provided, especially for construction? There's a place where you can reach out to Mike, and he will create your program based on your environment. I do believe, Mr. Mariachi, you do that.
Yes, there's more vowels in my name than I pronounce. I just make it simple for folks. It's Marachi will do it.
Marachi. There you go. Yeah. All right, there you go. So are there statutes of limitation for filing claims against employers? That comes from Linda.
Yeah, and I'll tell you, I had dealt with that with a fire chief. I also have a fire service and EMS version of the course yesterday, where he said an employee was sexually harassed by a coworker, and it was 2 years ago. Okay, and we're just finding out about it now. And I said, well, that thing is way too old, but don't still run your internal investigation, and you find your policy was violated. Okay, then you can deal with it, because there's no statutory limitation on enforcing policies, but employees need to know we're paying attention. Now, this chief I gave him a script for resetting the clock with his own staff to make sure everybody knows what happened 2 years ago. We won't be giving the details. It's not a reflection of our policy. Don't draw any conclusions that with it because this wasn't handled right in the past, we won't handle it right in the future. So I've got all kinds of clock reset script built into that so we can stop that from happening.
Yep. Bridget and Ruth are asking about slides being available. They will be made available, and you will have, we'll get the recording out as well for you, Bridget and Ruth. So we'll have that. Let's see, what is it? Best?
Yeah, there's a handout that that complements this webinar that you'll be getting.
You'll be getting that as well.
Yeah.
So best AAP approach for a company with almost exclusively remote employees operating out of 15 states, total of 65 EEs. That comes from Ruth.
The Office of Federal Contract Compliance Program requires employers to have affirmative action plans. If you've only got 65 employees at different sites, there's no affirmative action plan requirement at all. Okay, it just doesn't exist.
There you go, Ruth. That was one that you put in the way coming in. This is fantastic. Vonnie says, how to address a narcissist, someone who plays the blame game.
One of the most popular sections in corrective action is how to handle personality and attitude problems inside an organization. And there are some scripts built into that thing that solve that problem. But I don't want anybody to be intimidated when you confront an employee about this, thinks you can't do it, because this is on the employer's rights. There is a way to handle that. Okay.
Yeah. That's fantastic.
What I
love
will
it.
tell you is that once I put this program on site, I do not charge anybody for follow-up assistance. My job is to make them self-sufficient. If I haven't done that, that's my problem, not theirs. They get help, they don't get bills. So,
Yep.
so
So we are going to ask the folks, what do you need? I want to schedule an on-site training program with Mike. More information on the on-site program, because that is why we're here. We're here to help you get to where you want to go. That's how Mike makes his living. So while you don't have to purchase from anybody, you certainly can purchase from Mr. Marachi. He is absolutely, it's absolutely something that he does on a regular basis. I'm hoping that you all got an incredible amount of information from Mike. There's a whole lot of additional information. Mike and I talked in the prep of this briefing, and what I loved about it was he takes when he's talking about specific items. I know you had a lot on your plate today to get out for everybody to give them some really good tangible things. I think some of the scripts that you're talking about, the fact of engaging people, not avoiding people, making copious notes about what you said, and then making that report very, very important. And it resolves, it doesn't necessarily resolve the issue, but it resolves the challenges against you and what can come to you. So
I tell you, Dave, if anybody ever told me that I would have put 30,000 leaders through a 2-day program in 3 countries, I just told them they're out of their mind, but I have done it.
Yes, you have. And we're not talking about little guys either.
No.
Some of the folks you're talking about are real players. And the fact that you come at it from avoiding, you mentioned you're a recovering lawyer.
Mm-hmm.
I love that. So yeah, when you talk about removing that, the whole fist fight, the legal fist fight, the legal world just is not the place to take it. So we'll leave that open for a couple more seconds, and let's see if we have another questions here. Let's see. So Gia asks, how do you obtain managers' buy-in and understanding of the topic, specifically how subtle work practices behavior can create risk? Great question. That's a great question.
Okay, that is exactly the focus of this program. I explained to them, how do you disassociate yourself from discriminatory comments? How do you deal with the comments made by subordinates of yours, others, your peers, people above you, people on the outside? And I say, well, we discuss all these rules. Do you have any remaining questions on them? Ask them now. I deal with all their questions. And I say, okay, there are any further questions? No. Okay. Based on what we've just covered, the expectation is you're going to fulfill your responsibilities the way your policy requires and the way we've talked about it today. If you're going to do that, great. If you're not going to do it, raise your hand now. No hands go up. I've just reset the clock. I do it on sexual harassment. I do it on discharge. I do it on every conceivable thing, performance appraisal. So they have actually made a commitment, and they understand if they follow these rules and there's a legal challenge, they will be defended at no cost to them. If they've made a commitment to follow these rules and then they don't keep the commitment and there's a legal challenge, they won't be defended. And good luck with your own attorney.
Yeah, right.
Okay.
I love it. I love that you're always about keeping people out of any of the legal pieces. I think
I mean, some of the questions that I get asked, okay, Mike, you've told us all this. Now, if I really want to discriminate against somebody, how do I get away with it? Well, that was the last time that individual spent in that company. That was a leader that got fired that day.
If I want to discriminate against them,
how do I do it?
That's crazy. So anyway, we would just say thank you to everybody for joining us. Reach out to Mike because he is a wealth of knowledge. Be glad to give you some additional insight. His program is a 2-day program and I will go back to that slide real quick. It's a 2-day program, up to 48 folks max. And so you're talking about the ability to get to a whole bunch of people.
Well, see, I don't charge by the head. And there have been organizations that have put twice that number in the room, but I've told them once you get above 48, well, what's going to show up in the evaluation is they're unhappy with their employer because you don't have enough time for us to get our questions to Mike. Okay.
Yeah, love it. Awesome. Well, there you go. Reach out to Mike. And anybody that asks for anything, we'll get you some information. Everyone will get a copy of the presentation as well as the recording so that you can play it over and over again and put it in for some kind of award in Hollywood. So with that, thanks again, Mike. Great stuff. We'll catch up. I appreciate it, and we'll get everything that everybody needs. Thank you much. Oh, we do have one more chat. Let's see if there's a chat here that we can hit before, if they already left, maybe not. Super webinar, valuable tips and hints. Thank you very much. You're welcome, Ruth. You can come again. All right. Thanks much.
Thank you.
You bet.